The courtroom was quiet when the judge finished reading the decision. No raised voices. No dramatic outbursts. Just a pause long enough for the weight of the ruling to settle. Erika Kirk remained seated as custody of her children was awarded to their paternal grandparents. According to those present, she began to cry not loudly, not theatrically, but in a way that suggested this was a moment she knew might be coming, even if she wasn't prepared for it. This wasn't a viral clip. This wasn't a headline engineered for sympathy. This was family court where outcomes aren't decided by public opinion, but by what the state believes is safest for children. And before we go any further, if you value serious, fact-based true crime coverage that prioritizes accountability over outrage, take a moment to like this video. Share it with someone who follows these cases closely. Subscribe to the channel and comment below with your thoughts and let me know where you're watching from. Your support helps keep these conversations grounded and responsible. Because the question now isn't whether Erika Kirk is grieving. The question is whether the court believes her children are better protected without her primary custody. And once a judge answers that question, everything changes. This story is not about internet backlash. It is not about political affiliation. And it is not about whether the public sympathizes with a grieving widow. What happened in that courtroom was the result of a child welfare determination, the kind that unfolds quietly, over time, and only reaches the public once concerns can no longer be contained behind closed doors. Family court operates under a different standard than criminal court. There is no requirement to prove intent. There is no need for a crime to have occurred. The only question that matters is whether children are safe, stable, and supported emotionally and psychologically. In this case, the court determined that the children's paternal grandparents were better positioned to provide that stability, at least for now. That decision didn't appear overnight. It followed months of reported concerns, professional evaluations, and state involvement. And once child protective services in the court step in, the focus shifts away from public narratives and toward documented behavior. This is why moments that once appeared personal or private are now being examined under a different lens. Not for their emotional impact online, but for what they may indicate about parenting capacity behind the scenes. What makes this case especially difficult is that it sits at the intersection of grief, visibility, and responsibility. A family coping with loss, children processing trauma, and a public figure whose private decisions are now subject to legal scrutiny. And from this point forward, control of the story no longer belongs to the individual at the center of it. It belongs to the court, according to reports from the proceedings. The judge ruled that primary custody of the children would be awarded to their paternal grandparents. This decision was not framed as a punishment. It was framed as a protective measure. In family court, custody rulings are based on what is known as the best interest of the child standard. That standard weighs several factors: emotional stability, daily caregiving, consistency, and the ability to meet a child's developmental needs during times of stress or trauma. The court's order reportedly grants the grandparents day-to-day responsibility, while outlining specific conditions under which Erika Kirk may continue to have contact with her children. Whether that contact is supervised, structured, or subject to review depends on ongoing evaluations and compliance with court directives. It's important to understand what this ruling is and what it is not. This is not a termination of parental rights. It is not a criminal conviction. And it does not permanently sever the relationship between mother and children. But it is a clear signal. When a judge places children with grandparents, It reflects the court's belief that familiar family members, removed from the instability under review, can provide immediate continuity and emotional grounding. These decisions are rarely made lightly. Judges rely on reports from social workers, therapists, and child welfare professionals, people trained to assess risk, not just in moments, but in patterns. In this case, the court appears to have concluded that the children's current needs outweigh the importance of maintaining primary custody with their surviving parent. And once that determination is made, the legal trajectory of a family changes dramatically. Because from this point forward, every action, every decision, and every public move is viewed through the lens of compliance and capacity. Cases like this do not begin in a courtroom. They begin quietly, often with concern expressed by someone close enough to see what the public cannot. According to multiple reports, the initial involvement of Child Protective Services came after a complaint was filed by someone inside the children's daily environment. Not a stranger, not an online critic, but an individual with direct access to the household and first-hand visibility into day-to-day caregiving. That distinction matters. When CPS receives a report from an internal caregiver, it is typically taken seriously because it suggests ongoing observations rather than a single isolated incident. Once the agency became involved, investigators reportedly conducted home visits, interviews, and welfare assessments. These are standard procedures designed to determine whether concerns meet the threshold for court intervention. What followed suggests they did. According to available information, the findings prompted immediate action rather than informal guidance. The court reportedly ordered structured interventions, including therapy for the children on indication that professionals believed emotional harm or risk was present and required formal oversight. This was not framed as optional support. It was a mandate. As evaluations continued, the court began exploring alternative placement options. In family court, that step only occurs when judges believe a child's current environment may be contributing to instability or distress. At that point, the focus shifts from parental intent to parental outcome. The question is no longer whether a parent is trying. The question becomes whether what is happening is working. And according to the trajectory of this case, the court concluded that further oversight and eventually a change in primary custody was necessary to protect the children's well-being. At the center of this case are two children who lost their father suddenly, an event that for adults is life-altering and for young children is often impossible to fully process. Children at that age do not experience grief in a linear or logical way. They experience it in fragments, through questions that repeat, through regressions in behavior, through emotional swings they don't yet have the language to explain. Family courts understand this. When children are very young, stability is not just important, is critical. Consistent routines, predictable caregivers, and emotionally present adults become the foundation that allows a child to feel safe while navigating loss. According to reports referenced in the proceedings, concerns were raised about how the children were coping day to day, not in a general sense, but in ways that suggested prolonged distress, frequent confusion, repeated questions about their father, difficulty regulating emotions. These are not failures on the part of children. They are signals, and courts are trained to respond to signals, not sentiment. This is why grief counseling and therapeutic intervention are often ordered immediately after the death of a parent. Not as a judgment of the surviving parent, but as a safeguard for children who are too young to advocate for themselves. In this case, Therapy was reportedly ordered only after state involvement escalated. That delay became part of the court's broader assessment. Because when children are grieving, timing matters. Support delayed can become harm prolonged. From the court's perspective, the priority is not how grief is explained publicly, but how it is being processed privately and whether the adults in charge are equipped to guide children through it in a healthy, developmentally appropriate way. And this is where the court's concern appears to have deepened. Publicly, Erika Kirk has presented herself as composed, forward-moving, and purposeful in the wake of her husband's death. Interviews, appearances, and carefully framed statements have emphasized resilience, faith, and strength. But family court does not evaluate presentation. It evaluates consistency, according to information reviewed during the proceedings. The version of events shared publicly did not fully align with the concerns being documented privately by professionals involved in the case. This disconnect is not uncommon in high-visibility families. When a personality's typchen, moments that might otherwise remain private become part of a broader narrative, sometimes unintentionally, sometimes by design. One moment in particular drew significant attention. A story shared publicly about explaining the father's absence to a very young child. Framed as a tender, spiritual explanation, it was received by some as comforting. But professionals often evaluate such moments differently. In child development, the way loss is explained matters just as much as the fact that it is explained. Young children interpret language literally. Concepts like permanence, choice, and responsibility are still forming. According to child welfare experts, metaphors that imply absence as temporary or voluntary can create confusion, guilt, or misplaced responsibility in children who are already struggling to understand loss. While the court does not rule on social media posts, it does consider what those moments reveal about parenting approach, especially when they align with broader concerns raised by caregivers and therapists. In this case, what was intended to reassure publicly may have reinforced concerns privately. Because when image and outcome don't match, courts defer to outcome. Grief does not affect parents and children in the same way. Adults may intellectualize loss. Children feel it viscerally, without the ability to separate emotion from self-blame. Family courts are trained to recognize that grief, especially sudden and traumatic loss, can temporarily impair a parent's ability to provide consistent emotional regulation. This is not a moral judgment. It is a clinical observation. When a surviving parent is navigating their own trauma, they may unintentionally prioritize coping mechanisms that help them function day to day, while underestimating the depth of support their children require. This is why courts rely heavily on third-party evaluations. Therapists, social workers, and child psychologists assess whether a parent is emotionally available, responsive, and capable of managing both their grief and their children's. According to reports tied to this case, professionals expressed concern that the children's emotional needs were not being met in a sustained or developmentally appropriate way. Not because of malice, but because of misalignment. Grief narrows focus. It consumes energy. And when combined with public obligations, visibility, and pressure to perform resilience, it can leave very little room for the unstructured, repetitive, emotionally draining work that young children require when they are grieving. From a court's perspective, intent does not outweigh impact. If a parent's grief is interfering with their capacity to respond consistently to a child's needs, intervention becomes necessary not as punishment, but as protection. And in this case, the court appears to have concluded that additional safeguards were required. In family court, grandparents do not step into custodial roles casually. When they do, it is almost always after other options have been considered and concerns have gone unresolved. According to reports surrounding this case, the children's paternal grandparents had been involved long before the custody ruling was issued. Their involvement was not sudden, and it was not reactionary. Sources familiar with the situation indicate that they raised concerns privately first. They encouraged stability. They urged a slower pace. And they emphasized the children's need for consistent presence during an already destabilizing time. These efforts, according to those reports, did not result in meaningful change. From a legal standpoint, this matters. Courts expect families to attempt internal solutions before seeking state intervention. When those efforts fail, escalation becomes more defensible in the eyes of the court. The grandparents were reportedly prepared to provide full-time care, familiar routines, and an environment anchored in continuity, something courts view as especially important for children coping with trauma. It's also important to note that custody petitions from grandparents are often framed not as opposition to a parent, but as a response to urgent need. The court does not interpret such petitions as power grabs. It interprets them as protective when supported by evidence. In this case, the judge's ruling suggests that the grandparents' concerns aligned with the findings of professionals involved. Once that alignment exists, courts tend to move decisively. Because when multiple independent parties raise the same concerns, it becomes harder to dismiss them as misunderstanding or bias. A custody ruling like this does not exist in isolation. It carries consequences that extend well beyond where children sleep at night. Once a court determines that a parent requires oversight, that assessment follows them. Future decisions about visitation, modification of custody, and even public conduct are now evaluated against an established legal record. For Erika Kirk, this ruling alters the way every subsequent action is interpreted. Public appearances, statements, and choices are no longer viewed solely through the lens of personal autonomy, but through compliance and capacity. This is particularly significant for someone whose life unfolds in public view. Courts may impose ongoing requirements, continued therapy, parenting evaluations, structured visitation schedules, or periodic reviews. Progress must be demonstrated, not asserted. Reputation is also affected in ways that cannot be easily repaired. While family court proceedings are often sealed, outcomes are not invisible. Public trust shifts when child welfare concerns enter the picture. Supporters may hesitate. Defenders may distance themselves. And institutions that once aligned themselves closely may reassess that association. None of this is symbolic. It is procedural. Because once the state intervenes on behalf of children, the presumption of full parental authority is no longer automatic. It must be re-earned. From here, the path forward is defined by process, not perception. Custody rulings in cases like this are subject to review, but they are not easily reversed. Any modification requires evidence documented, sustained, and independently verified that circumstances have changed in a meaningful way. For Erika Kirk, that would likely involve full compliance with court-ordered requirements. Continued participation in therapy, demonstrated consistency in visitation, and professional evaluations indicating that the concerns which led to state intervention have been adequately addressed. Time is also a factor. Courts do not rush reunification when children are still stabilizing. The priority remains continuity, not speed. Even well-intentioned efforts must be measured against how children are responding emotionally and behaviorally. If the grandparents continue to provide a stable environment, the court may view maintaining that placement as the least disruptive option especially, while the children process grief under structured support. There is also the possibility of further legal action. Appeals can be filed. Custody arrangements can be contested. But each step adds scrutiny, not relief. The legal spotlight does not dim, it intensifies. At this stage, speculation carries little weight. Only documentation matters. What happens next will not be decided in interviews or statements. It will be decided in reports, evaluations, and review hearings. And those proceedings will unfold quietly, away from public commentary. When cases like this reach family court, they stop being about narrative and start being about responsibility. The judge's decision was not a verdict on grief. It was not a statement about faith. And it was not a referendum on public sympathy. It was a determination about what children need right now to feel safe, supported, and stable in a world that changed for them far too suddenly. Custody rulings are never clean. They leave adults hurt, confused, and often defensive. But the court's role is not to protect adult identity, it is to protect children who cannot yet protect themselves. Whether this decision remains in place or changes over time will depend on actions taken when no one is watching. Not on statements made for an audience, but on consistency demonstrated in private. Because in the end, this case is not about who appears strongest. It is about who provides the safest ground for healing. And that question quiet, uncomfortable, and deeply human is the one the court has already begun to answer. I'm Detective B. If you're fascinated by real life, mysteries, and criminal investigations, tap like, subscribe, and share your opinion in the comments. I'd love to know where you're watching from and what you think about today's case. Make sure to subscribe and turn on the notification bell so you never miss a new episode. Until next time, stay curious, stay vigilant, and remember, in true crime, the line between fact and perception is often thinner than we realize.